the room and of course also at the Ladies College. I just want to continue with what my colleague explained before the break. He explained about how to draft a patent application, and I want to go into some more detail what happens afterwards, after the patent application has been filed, and I will concentrate on the European aspect, because we as a German law firm and European patent attorneys are most experienced in this field and a little bit less in the USPTO, although of course we also file applications there via associates in the United States, but they have different ideas of how to examine a patent, and this should be left to an expert from the United States to explain that a little bit more, so I will concentrate on European patents. And with a patent application, there are basically two aspects I would like to go into some more details. One is the quality of the patent application, which is of course very much governed by what has been drafted in the first place in the patent application, because there is always a rule that you are bound to the original disclosure, so you can not expand at a later stage in a very extensive manner what you have originally written in a patent application. You cannot add any new matter, or only with a very restricted, within very restricted limits, like for example adding some comparative results, but not to the substance of the invention. And the other aspect is the speed. So how quickly am I able to obtain a granted patent after having filed a patent application, because the full rights from a patent are only obtainable after the grant. So after the patent office has examined for the basic criteria of patentability, which are three, which is novelty, so not having been disclosed in the prior art in exactly the same way. The second is the inventive step criteria, which means that it has to be non-obvious for someone skilled in the art, having the full picture of the prior art. And the third one is usually not a problem, is industrial applicability, usually everything which is developed during research and development is industrially applicable. But the first two criteria of novelty and inventive step will have to be examined very carefully by the patent examiner of the European Patent Office, and this then hopefully results in a patent grant, and only then you have the full protection, so giving you the right to prevent others from imitating what you have invented. So the speed of the whole process is quite an important feature, and there are different possibilities to speed up the procedure at the European Patent Office, and two of them I want to explain in a little bit more detail. The first one is the so-called Patent Prosecution Highway Program, which has first been started in 2008, only 2 years ago, together with the United States Patent and Trademark Office. Earlier this year it started with the Japanese Patent Office, and also now can rely on the results of the search in PCT applications. What is the basic idea behind this? It's to avoid double or triple work in the various patent offices. In order to speed up the procedure, you try to rely on what an experienced examiner in another patent office has already found during his search, and which would of course then make the work of the patent examiner easier if we can at least partly rely on what a colleague, for example, in the United States or at the Japanese Patent Office has produced as search results and opinion on the patentability. This works in both directions. So if filing at the EPO, you can use the results of the search and examination of the USPTO or of the Japanese Patent Office. And also if you are going to file in the USPTO or the Japanese Patent Office, you can try to have the results used which have been produced at the European Patent Office, whichever is the quicker one and the easier one. How does the system work? So there are some prerequisites to enter this patent prosecution highway. The first one is that you have an earlier application in another country, so in the United States or Japan in this case, or a PCT application. Then there must be available results from this patent office, so an opinion of any of the other patent offices on the patentability of claims. So there must at least be one claim which has been indicated by this other patent office as patentable. Then your claims, let's take the example, you are trying to use the results of the United States Patent Office for the prosecution of a European patent application. Your claims must be in conformity with the claims which are found to be allowable, should not go beyond that. So all of your claims has to conform with the claims found allowable, for example, in the United States. And then you can file a request with the European Patent Office, submitting the results from the United States Patent Office or Japanese Patent Office, and requesting to participate in the pilot program. And the last prerequisite is that the examination at the European Patent Office has not already started. So if they have already started their work, they will go on with it. If they have not started, and you fulfill the prerequisites I've just mentioned, then you can apply for just participating in this program. And usually they will allow these requests relatively rapidly. So I've just recently filed such a request for a Japanese client of mine who is in the cosmetic field, and they already had the search opinion and examination report of the Japanese Patent Office when filing the European patent application. So immediately after filing it, we submitted these results with the European Patent Office and requested participation in this specific program. And they have, after only some weeks, accepted this. Some weeks is relatively quick for a patent office. And now we are waiting for their evaluation of what the Japanese Patent Office has already said with regard to patentability. This, as you see, is a pilot program, so this is not a fixed schedule. It has been designed, the first one from 2008 to 2010 for 2 years for the USPTO. It has been now extended for further 2 years, and these 2 years are also the same period which has now been given to the pilot program with the Japanese Patent Office and with earlier PCT applications. And the US program has, of course, been extended to have the same termination of the pilot programs with all the patent offices. So in 2012, there will be a final evaluation, I guess, and then it will be decided through or in cooperation of the 3 patent offices whether they will continue to use it, whether they have found it to be useful for their work and to speed up their work or not. So this is an interesting approach and really avoiding multiple work, decreasing, of course, the workload of the individual patent offices, and hopefully speeding up the whole patent prosecution and examination process in at least those 3 patent offices. Then there is another program which is already relatively old at the European Patent Office, which is called PACE. PACE is, of course, a self-explaining word. It's an abbreviation for something, I forgot what, but it's, of course, speed is another word for it. So the word in itself says that this is a program to speed up the examination. How does this program work? If you have a first filing in the European Patent Office, it's very easy because you have nothing to do. if your priority first filing is at the European Patent Office, it is automatically within the system, and they guarantee, more or less guarantee, they at least say that they will do their best to provide you with the search results within 6 months from the filing date. So within the first half year, which gives you then enough time to take the decision whether to file in other countries, which is possible within 1 year. My colleague Heinz Goddar will go into details of the filing strategies in the next presentation. So this is very early. Then it's a little bit different if your patent application claims the priority of another one. So if your first filing was here in Saudi Arabia, or whether your first filing was, for example, in the United States, and you later on file an application at the European Patent Office claiming the priority of the first filing, then they only say that they try to do their best to give you the search results as soon as possible. But they are very vague in that, so they're not giving a fixed time limit as for first filings, where they say within 6 months you will receive that. For entering this program with a priority application, you have to file a specific request. So you have to send just a short letter to the European Patent Office just saying we request this application to be handled under the PACE program, and usually this will be granted. You should, as an applicant, avoid to file such request for all of your applications. So if every applicant for all his applications would file such a request, you are in a stuck situation, because then you cannot prioritize your cases at the patent office. So they will look into that, and if they see that there is kind of an abuse of the system, so a client trying really to have all the cases, they might write back to you and say, do we have specific reasons for applying for the system? And if you can then come with convincing reasons, for example, that commercialization, for example, is already intended, that you have already a cooperation partner in industry who is interested in having an early patent protection, then I'm quite sure that this will also be granted, such a request to enter the PACE program. These requests can both be requested or filed for the search of a patent application and for the later on examination. It also requires that you are responsive to what the European Patent Office does. So if they send an office action and you take the full term they are granting you and then requesting for an extension of term, so that they have the impression that you on your side are kind of delaying the procedure, they usually do not find themselves any longer bound to speed up on their side. So what they want is cooperation, and if they see the applicant is very responsive, reacting in a short term and in a substantive manner, so really answering and replying to all the issues of the office actions, then you have a good chance to have an accelerated procedure at the European Patent Office. There is a change in the rules of the European Patent Office, which will come into force January 1st of next year, which is also intended to speed up the work of the European Patent Office, namely that you now have or will have the duty to submit information on prior art, which is already available to you as the applicant to the EPO. So this rule only applies if you have an earlier priority application and if there is prior art already available from the examination and search for this priority application. Example again, you have filed first in the United States, then after a year in the European Patent Office, and either already at the time of filing at the European Patent Office or a little bit later, the search results of the United States Patent Office will become available, you now have the duty to submit these results to the European Patent Examiner to help him to do his work for the search. He will nevertheless do his own supplementary search, but at least he has a good starting point, a good basis for going on. So we all hope that this will also help to speed up the procedure. They can also ask, this is a different rule which in the EPO and the EPC, they can also ask to provide them with results from parallel procedures. So if you have not filed a priority application in another patent office, but if you have a number of applications filed in different patent office, and if they know this because they can easily retrieve this from the internet, whether you have other applications in other countries, they can ask you to submit also results from these parallel procedures. This is a little bit comparable from what you might know from the United States, where you have an information disclosure duty and where you have to file explicitly an information disclosure statement. It's a little bit less formalized in the EPO. There are no immediate consequences if you are not fully complying with the rules, so it will not automatically be seen as fraud of the patent office. There is a consequence if you do not react at all to any communication requesting you to file something. There will be some automatism to say that the application will be deemed to be withdrawn. You can then request further processing, which is just a simple request and a payment of a fee. But if you, at least there's nothing in the EPC going into detail, if you would not be completely complying with these rules, I do not see any automatism for a legal consequence there.
Okay, doctor, you have 5 minutes.
5 minutes, okay. This is short. So you can do this in various stages, so I will not go into that. What might be interesting for you, if after you have done this, at the first reaction of the European Patent Office, you will receive what you may already know if you have filed patent applications at the European Patent Office, which is called Extended European Search Report, and which gives you two kinds of information, both the search of the results, and from this information or communication of the European Patent Office, you can get various information on prior art documents. And you will find on this not only the numbers, the passages in the documents which are relevant for your applications, the information for what claims this is seen as relevant, but also symbols. And these symbols have specific meanings which are explained in very small letters at the bottom, but you have perhaps not read to that. And the most important letters I have put here on the screen is the X, which is meaning that the examiner believes this document to be novelty destroying, so very critical prior art. A Y being relevant for inventive step in combination with another document of the search. An A is a very positive symbol because it says it's only relevant for technological background. And then there are some specific other things which are related to specific time schemes, intermediate document, so this, which is a document filed between the priority and the filing date, or an earlier patent document which has an earlier priority but published later. So with different consequences, but due to the time constraints of today, we don't have the time to go into detail. The second very important information you get from the Extended European Search Report is a written opinion on the patentability, which is kind of the first office action already. And this goes into all the details of what you should fulfill in order to get a patent grant. So this is, they very often deal with the support of the claims in the specification. They very often go into the issue of broad claims. So if they feel that the claims are too broadly formulated and not supported fully by the examples and the specification, they will raise an objection. the clarity of the claims, what we have already heard from my colleague. So vague terms are usually discussed there. Then, of course, novelty is an aspect, so they will go into make a comparison of the closest prior art documents and point to things which they believe to be relevant for novelty. And then, of course, inventive step, following the problem solution approach, which has already been a little bit elucidated by my colleagues. So you have to establish the closest prior art, define the problem, identifying the used solution, and then evaluate whether your solution has been obvious for someone skilled in the art or not. You have to react to this European search report within specific time limits, which can be relatively short. So what you shall do is you should carefully study the extended European search report and provide your lawyer, your patent attorney, with information, with your thoughts and comments on the prior art, so that he will be able to react and reply to that extended European search report in good time. Usually this is not the end of the story. There will be more reactions and communication with the patent office, usually one or more office action, raising similar points. There is one point which comes in addition to what is discussed in the extended European search report, which is original disclosure. So whenever you amend claims, and this is very often during the patent prosecution, that you see the prior art and you have to reformulate the claims to delimitate from the prior art, that you do not enter new matter into the claims, that you are not broadening your claims, and that these amendments are clearly based on your original disclosure. And the European Patent Office is very, very strict on that and very formalistic. So you must be sure that the formulation you take into claims has been literally been disclosed in your original patent application. Other patent offices, like the German Patent Office, are much more tolerant in this respect, but to be sure, the European Patent Office is very strict, and you have to obey to that. Okay, you have different ways to react. You can react in writing, you can have an interview with the examiner, you can request and have oral proceedings before the examining division. You can even have now this in a video conference, because these oral proceedings can take place both in Munich and in The Hague in the Netherlands. So if you are, for example, located in Munich, it's very easy to have an interview in Munich, but it's very difficult to have it in The Hague, because you have to travel. Then you can have a video conference. And upon approval of the claims, you have to adapt the specification to the claims which are allowed and discuss the prior art cited during the examination procedure. And then you are finally in the grant procedure, where you have to fulfill some formalities like paying fees for the grant and the printing. And then hopefully at the end you have the granted European patent, which then would give you the rights. And with this, I would like, I know I have used more than 5 minutes, but I wanted at least to briefly touch on the issues.
Okay.
And,
should have gave you more time, but there's
no problem. I
other,
perhaps we have time for one or more questions. Or
yeah, we'll have. Please, the floor is open for questions.
Okay.
And if somebody want to. Yes, please. Introduce yourself, please.
Yeah, I just want to ask about the American system and...
it's difficult to understand because your mic...
Should have the mic. Okay, sure, sorry.
Thanks for your presentation. I just have a little question. In the American system, you just file one application, and you know, the American market is open for you, a very huge market. And on the other hand, if you file in the European system, then you have to follow these applications in individual countries. You have to translate, and you have to follow up. I mean, is it that appealing? I mean, to file through the European system if you have to, you know, have like this budget for these translations and the cost for that?
Yeah, I fully understand your question. I'm not sure. I think my colleague will a little bit elaborate on these. So just a short answer. Whether it's useful to file a European patent application depends, of course, on your commercial interests. The European market is, of course, as a whole, quite interesting. But the usual strategy after having gone through the centralized examination and grant procedure at the European Patent Office of most of our clients is to choose only a small number of countries later on for so-called validation of the European patent. So a choice or selection of only a small number of countries where you really want to follow up. Very fortunately, the more important